The more they dig, the more that they find. And I thought I was over talking about Letitia James because we covered a few different aspects of this investigation. But now something new pops up that I want to bring to you because I want to make sure you understand what you should and shouldn't do if you're faced with these situations. Now, if you're not familiar with the case, and you want to learn a little bit more about it, I'm going to link right here where you can click. You can learn about the part that we're going to talk about somewhat today of her on the mortgage application, naming her father as her husband. So, welcome back to the Real Estate and Wealth podcast, and I make real estate easy for you. Do me a favor if you're new here, make sure you subscribe and hit like on this episode to help me out. Okay, so today we're talking about the probate aspect of this situation. Now, and we're talking about the Queen's property. After her father passed away, she took 13 years to start the probate process for this property. Now, you might be saying, what's wrong with that? Well, in New York State, there is no limitation on when you should file probate on a property, but they expect that you would do it in a reasonable amount of time. And a reasonable amount of time might be maybe 1 to 3 years, right? Depending on your mental state, emotional state. Maybe it's a big estate and there's a lot that needs to be dealt with. Now, I can tell you that when my father passed away, it took me about 1.5 years to settle his estate. But I started sooner rather than later, and that process was 1.5 years. But 13 years, do you think that that's a reasonable amount of time? Do you think that it should have been done sooner? I don't know. I'm not going to say whether if it should or shouldn't. But what we will talk about today is just this whole process and what it means for you if you're buying a property with a spouse or family member, and how you should take ownership of that particular property. So now we mentioned that she bought this property as husband and wife with her father. That sounds so weird to say. But when you buy a property as a married couple, the way you would take ownership of the property is one of two ways, and it could just depend on the state that you're in. You can take it one as tenants by the entirety, or two, joint tenancy. Here in the state of Maryland, if you're married, you would take it as tenants by the entirety. What does that mean? That means that you're looked at as one person. So you don't have shares in the property or anything like that. And there is right of survivorship. That means that if one of the spouses passes away, the property automatically goes to the surviving spouse, and it does not need to go to probate for that. You also can't sell any shares of the property because technically you don't have shares like maybe some of the other ownership types. So with this type of ownership, tenants by the entirety, it works for married couples because it makes that process a little bit easier if a spouse passes away. So if they did buy this property as husband and wife, they took ownership as husband and wife. When her father passed away, it should have automatically transferred into her name. But that did not happen, and hence the question mark around this whole situation. The problem comes in is when she filed probate in 1999, 2000 timeframe, she had to put the property through probate. And it was claimed that it was tenants in common. And for tenants in common would not be for a married couple. Now, let's talk about what tenants in common is. For tenants in common, generally the person that would take ownership, tenants in common, it could be family members, friends, a couple that's not married, but with tenants in common, you do own shares, and they don't have to be equal shares. It could be one person has 30%, the other person has 70%. If there's more than two people, maybe there's three people that are buying a property together. You each can own 33%, or it doesn't have to be even like that. You get to choose, and it could be based on how much money you invest into purchasing the property would determine what percentage that you have. But a big part of tenants in common is that with your shares, there is no right of survivorship. So if one partner in the property passes away, it does not automatically go to the other two people and then they now split it 50-50. What will happen is their percentage of that property now can be willed down to someone else. It could be to their children, it could be to a friend, it could be to whomever they want to have their shares in this particular property. And you can imagine if you're living in the property with this person and they will their shares to someone else, you could potentially own this property with someone that you don't even know. So it's important to understand how you're taking ownership of the property. And in this situation, she is claiming that, I guess when she did the probate, that it was tenants in common, when it should have been either tenants by the entirety or joint tenancy. Now, let's talk a little bit about what joint tenancy is. Joint tenancy is very similar to tenants by the entirety. So tenants by the entirety is just for married couples. Joint tenancy can be for couples, partners, but you're not married, but you want to have some of the same benefits of tenants by the entirety. So with joint tenancy, you do have right of survivorship. So you can have, if one person passes away, their shares goes directly over to the surviving partner of the purchase. You do have shares of the property, but if you sell your shares, then it severs the right of survivorship portion of the benefits that would come with it. And with joint tenancy, each person has equal shares, unlike tenants in common, where you can have unequal shares. With joint tenancy, you have equal shares. So that's important to know. If someone passes away, it does not have to go through probate in order to pass it off to the other person, the right of survivorship. So, as you can see, how you take ownership of the property is very important. It might not be right now important, but it is important if someone passes away, what happens with the property. If it's joint tenant or tenants by the entirety, there is right of survivorship where it will automatically pass on to the surviving partner, and you do not have to go through probate in order to do that. Unlike with tenants in common, if someone passes away, their shares can be willed to their heirs or whomever they want to pass that on to. And you do have to go through probate in order to pass your shares onto the surviving party if that's how it is set up. So it's very important that you understand that, so that if you are buying a property with someone, you know how to take ownership in the property. In this case, I'm not sure what the motives were. I don't know if it was initially done joint tenancy, and then once it went through probate, then the title ownership was changed to tenants in common. I'm not sure if probate was filed 13 years later because maybe there would have been some tax implications, or what the benefit may or may not have been. That is going to be for the investigation and the courts to decide the fate on this aspect. But I wanted you to know how you should take ownership and also understanding this aspect of the case to see if this was all just a clerical error, or do you think this was done on purpose? Answer in the comments and let me know. And again, don't forget to subscribe to my channel for more real estate information. I look forward to seeing you guys on the next episode.